Hello, everyone. Good afternoon, at least in most of the country right now. I am AJ Weisler, and I'm excited to get a chance to talk to you all today about this presentation, which is avoiding 5 wage and hour mistakes that can sour your brew. Before we dive too far in, I figured you guys probably want a little bit more about me. I suspect this is the first time most, if not all of you, have seen me. So I am AJ Weisler. I'm a partner, labor and employment partner at Hush Blackwell. I'm a member of our food systems business unit. That's the strategic business unit of attorneys who work with folks in the food industry or in the specialization also of alcohol beverage. You'll see there's a can there. That's not me on the can. I just happened to find a beer that had AJ on it, and I first of all I felt seen and represented, and that felt great. And then it actually triggered this idea that today and throughout the presentation, this slide and others, you're going to see images of various craft beers because it turns out that your industry has managed to come up with a name for a brewery or a beer that combines virtually every possible combination of words and letters in the English language. You are a creative and prolific bunch. In no way should any of these be viewed as an endorsement of the beer. I've never tried the AJ Dunkelweizen that's on the screen right now. I'm coming to you today from Kansas City. That's where I'm based, but my practice is all over the country. So I do wage and hour law in virtually every state, and I'm licensed in 4 of those states, Illinois, Michigan, and Missouri, because I either live currently or have lived there recently. California, because, and you'll hear this as a theme today, if you deal with wage and hour topics like I do, minimum wage and overtime, all roads lead to California, where the regulations are certainly the strictest. I am an enthusiastic consumer of craft beers. And I throw this out there and tell everyone I can, whenever I can. I was a state math champion in 1997. The state was Missouri, which is like a top 45 state for math. So that's a pretty big accomplishment. I'm pretty proud of it. It also explains probably why, as a lawyer, I was drawn to the world of wage and hour law, because we get to do some math. We'll do a little bit of math today, not a ton. One other thing I should mention, I'm not a brewer. I've never brewed, not home or otherwise. I was destined to be a brewer. I think we throw 2 greats, 2 great grandfathers. My great was in Germany. I was a brewer there. He immigrated to the United States. His son and grandson, so my great grandfather and grandfather, were brewers. They worked for a small craft brewery in St. Louis named Anheuser-Busch, and one of them was there for 100 years worth of time. My father, instead of continuing the proud tradition of brewers in my family, chose to sell drugs, albeit as a retail pharmacist. And with that chain broken, I instead chose the law. So here I am, regretting many life choices, one of which is that I don't spend my days brewing beer. So let's start with how we got to where we are on a timeline from, we'll start in 1938, and it's going to carry us all the way to now. In 1938, in this country, we passed the Fair Labor Standards Act. It was a law that was intended to increase employment, right? Something was going on in the 30s where people didn't have jobs. And this law was intended to take one job where one person was working 80 hours and turn it into 2 jobs where 2 people each worked 40 hours. And so to do that, they disincentivized employees working long hours by creating an obligation to pay overtime. So if you've grown up, as I have, with this general understanding that if you work over 40 hours, you get overtime, it largely traces back to 1938. From then to 2004, from what I understand, nothing happened. I was alive for a good chunk of that, and I don't remember most of it. But in 2004, the U.S. Department of Labor issued some new regulations. They're in charge of administering the FLSA, is what we're going to call the Fair Labor Standards Act, at various times today. And they passed new regulations, and really all it did, changed some of the rules, clarified some things, but it really drew attention to the fact that this is a law that provides protections to employees and isn't really being, we'll say, enforced in the way that some others were, right? It wasn't very active. There weren't lots of lawsuits. And it's also a law that has rules, and we'll talk about them a little bit more, that make it really easy for one employee to sue an employer and represent all the rest of the employees. We sometimes call that a class action. You may have heard of that. You've probably gotten notices in your email because you bought some product that ended up being faulty, and you can get a coupon if you fill out a form. In this situation, it's not a class action. We call it a collective action. It's even easier to bring people together and sue an employer for these wage and hour violations or overtime, minimum wage, that sort of thing. And so since then, It has continued to grow. It reached a peak in 2021. It's leveled off some federally. Different states, California being an example, continue to grow. If you see the beer, they woke in 2004 a sleeping giant. You can't tell probably, but I'm quite tall. In case that helps give me a little bit more credibility today. So this is a slide for the young people who know about memes. This is a classic meme format. But the thing I want to talk to you all about today, as individuals who either are managers, employers, work in a space where you may have employees, it's anyone who's setting policy, making decisions about wage and hour. The message or the theme is that you can make a mistake today, right? That's well intentioned. It's honest. It's not, you're not sitting down in a boardroom saying, how do we pay our employees less and unlawfully, right? But you make a decision now, and over time, as you grow, as you add employees, as you increase your workforce, it's that small decision turns into a class or collective action. Now you have dozens, hundreds of employees all suing together, driven largely by a plaintiff's attorney who's interested in seeing how much of your bank account they can transfer to theirs. And it's the sort of thing that can multiply quickly. Again, there's that math we talked about. And so when I'm talking to you today, a lot of these things, understandably, are going to feel small, right? They're going to feel insignificant, and we'll talk various times about why we need to care about them and why it's important to care about them now. So a little bit of a roadmap Brewing from San Antonio, of today's discussion. So we're going to talk a little bit about written policies, because that's an important part of this. Some of you may have lots, some of you may have not a lot, some of you, may just be starting in this process of developing sort of formal rules around how you manage your employees. We're going to talk about why you need them and also how there's a little bit of risk there. Then we're going to get into those sort of 5 common mistakes, things that lots of employers, well-meaning, generous employers, can stumble into. Then we're going to talk a little bit about what you should be looking for in your own internal discussions that might flag a problem that might be coming. And then we're going to talk a little bit about what you can be doing even beyond watching and rewatching and memorizing this presentation to help with your compliance in this space. I know that there is a comment bar for anyone who's watching live. Would love to see any comments or questions that you have today. If you're watching in the future, feel free to add a comment. And assuming that I am as obsessive with checking comments on this video as I have been on others, I'll respond to it if I can. I'll also leave you with my email address at the end, and do feel free to reach out with any questions about today's topic. Would love to talk about it. So we talked about policies. A policy, even a perfect policy in this space, isn't perfect protection, right? So you can't just write the right handbook, pay a company to produce a handbook, pay a lawyer to review a handbook, distribute that handbook, have everybody sign it, and then be like, all right, we got wage and hour covered, everybody sign the handbook. Because that's not, unfortunately, what matters, right? So when we have a handbook, even perfect policies that tell everybody how to clock, how to get paid, what overtime is, unless that's actually happening on the ground, unless the practices, the way our supervisors, our managers, our HR, our payroll are implementing those policies tracks with the actual rules, the requirements, having a handbook that says all the right things doesn't solve the problem here. And this is an area of law where intent doesn't matter, right? Most of the time in most of these areas, it doesn't matter if you wanted to pay employees correctly. It doesn't matter if you took the time to put a policy in place that would have paid employees correctly, right? You have to pay them correctly. And if you don't, then there's risk, there's exposure, and we'll talk about what some of that looks like. And so it's important to not just take the time at the beginning or in response to a presentation like this and think, oh, we got to clean up our policies. Let's take a look at our handbook, right? Instead, you have to kind of live with this, and you have to make this and make sort of, your compliance with these things part of the culture and the experience that you all have. An imperfect policy is worse than not having one. And that's probably obvious, right, to those of you who are in a regulated industry. Putting onto paper something that is incorrect is worse than not putting it on paper at all. And that's definitely true in this space, because I mentioned before, these cases tend to not be individualized, right? If it's one employee worried about one little thing, not a big deal. These cases become significant when you aggregate lots of employees or multiple employees together. And one way that's easy for attorneys to do on the other side of these cases, I'm working with employers, the folks who represent the employees, they look for any policy that as written is wrong, and then they can take that policy to the court and basically say, here's a policy that appears to be unlawful. I want to represent everybody who's affected by this policy, and they're usually pretty successful. An example of what we mean by sort of like a well-meaning but often seen non-compliant policy is this idea of telling employees you have to have authorization for overtime, but also telling them that if they don't have authorization, they can't report or work or get paid for overtime. The better policy, and this is a freebie. There will be other policies we get into in more detail. The better policy, right, is to tell them you can't do it without pre-authorization, but you should record all of your time no matter what, right? And if you record time that wasn't authorized, we'll pay you for it, but we may also discipline you. So now we're going to talk about the first mistake. I actually borrowed this slide from a presentation that I did on my oldest daughter. So mistake number one. And mistake number one that we're going to get into today is misclassifying salaried employees. I would say of sort of smaller, mid-sized, growing employers, especially startups, this is a very common mistake. And it goes like this. You start hiring people to this business, you have an idea and a passion, they have passion, everybody is pulling together, you have a goal, you're working hard, everybody's working long hours, and you want to demonstrate, right, how important they are to the team, and you do that by giving them a salary, paying them some set amount per year, per month. You're generous, they feel well compensated, everybody is happy. And so, there's this common mistake where you suddenly start treating everybody as salaried, right? You give every person who comes on a salary, nobody's tracking their time, nobody's getting overtime. And so that leads to the common mistake of ending up with a group of employees who are salaried, who are treated as, you're going to hear the phrase exempt a lot today. Exempt in my space or not exempt is a reference to whether somebody is entitled to or not entitled to overtime. So exempt means exempt from overtime, not exempt means not exempt. They're entitled to overtime. And what happens a lot is you'll end up with a population of employees who you pay well, treat well, they feel well treated, but you're not tracking their hours and paying them overtime. And you're basing it purely on the fact that they're salaried. I think that there is a general perception, whether any of you hold it or not, that anybody who is salaried doesn't get overtime. And that is not how the rules work, because we have to look at what they actually do. So we refer to these exemptions from overtime and minimum wage. There's a common phrase called the white collar exemptions. It's meant to reflect that, look, manual blue collar workers deserve the protections of overtime because their work is hard and stressful and difficult. And we don't want to make them work 80 hours without giving them some sort of additional pay. Whereas, cushy white collar jobs like myself, my collar is mostly white today. We can sit at our desk and we can do it for 100 hours. It's not such a big deal. I think in 1938, cardiac issues were maybe as obvious. But there's three of them. So we have the executive, administrative, professional. Some people call these the EAP exemptions. The EAP has a different meaning in a lot of places, so I prefer to call them the white collar exemptions still. And only one factor of them is the salary. So you do have to pay them the right salary. Currently that's $684 a week. It went up briefly and then came back down based on a Biden administration rule and then a court invalidating that rule. But that's only part of the test, right? You do have to check that box, and that's the easy box to check. The next part of an exemption for your employees, if you're not going to pay them overtime, is they have to fit into one of these duties tests. So they have to have the primary duty of managing other employees. And it gets more detailed than that, right? They have to actually be involved in discipline or other important personnel hiring, firing decisions. Or if they're an administrative employee, they have to be involved in the administration of your business, and they have to have true discretion, independent judgment on matters of significance, right? They have to have a big budget that they're responsible for. They have to have big accounts, big clients that they're making decisions and strategic choices about. Or there's professional, which tends to be more of somebody with a degree. Law fits under that, where you have sort of a higher education degree, and the work that you're doing is based on that. Unless they fit within those job duties, just paying them a salary doesn't do it. And so what we end up happening, or what ends up happening, is you have an employee, somebody who worked for you. Here's an example, right? For years, you're paying them well. In this example, you're paying somebody $78,000 a year, which is $1,500 a week. I did that math myself. And ultimately, the relationship sours. They get fired. A lot of times what happens is they get fired and they're mad about getting fired. And so they go talk to a lawyer or they complain to somebody and they say, this is unfair. It was discrimination. It was bad. I shouldn't have been fired. And that lawyer listens to them and says, yeah, you don't have any kind of claim for the termination piece, but how were you paid? Let me see a pay stub. Oh, you were salaried. What did you do? And so that turns into not a discrimination, not wrongful termination claim, but instead they come back with a wage claim. And they say that they were misclassified. You weren't giving me overtime you should have been. They also will tell you how much they were working. 60 hours in these cases is actually a fairly modest number. A lot of times we get, an allegation of 80 hours a week, 100 hours a week. These people who probably didn't work that much suddenly are working more than anyone. And the challenge that you have is that you don't have time records because you didn't make them clock in and out because they were exempt. They weren't getting overtime, right? You don't have to track time for exempt employees. And so, and a lot of times these are the types of employees that while they were working for you, if you told them they had to clock in and out, they would have been offended. They would have thought it was beneath them. Not anymore. So they bring this lawsuit and all of a sudden you're defending it and you're having to prove that what they were doing qualified and the exposure is high, right? So they're going to seek unpaid overtime. And under the federal law and a lot of state laws, you go back at least 3 years. Some state laws go even farther than that. You can also go after not just the unpaid overtime, but the liquidated damages. That's a phrase from federal law that basically is like the amount on top of the unpaid wages. It's kind of a penalty on employers. It's also meant to reflect like, loss ability to use that money over time, interest, things like that. But it's an amount equal to the wages. So if I underpay somebody $10, they can get liquidated damages for another $10, and now I owe them 20. And then they also get, if they win, they get their attorney's fees paid. So that last bullet, right, is what motivates most of these cases. Because if I'm an attorney on the other side of these cases, I think, all right, I'm going to press this. And if I win, even if I don't win a lot of money for my individual plaintiff, I'm going to be able to get my attorney's fees paid by the company as well. And the exposure gets high quickly. When I mentioned we do a little bit of math. So, you have an employee, this person was getting paid, like we said, $1,500 a week. If that was paying them for 40 hours, that's somebody who's making $37.50 an hour. And now they're going to be claiming 20 hours of overtime. You do the math on that, and they're claiming $120,000 in unpaid overtime. And the trick to these misclassification cases, or I guess, the unfortunate consequence is the more you paid your employee, like the higher the salary, the more generous you were with them on their compensation side. If they don't meet the duties test, the more risk there is for you that if they ever come claim an entitlement to overtime, you're going to owe them a whole bunch of money. And this is oversimplifying. Most of what we talk about today will be a slight oversimplification. There are defenses and there's ways to try to bring these numbers down. But ultimately, that's the type of number that we will see early in a case. You double it by adding the liquidated damages, and this one employee over their 3-year period is going to be looking for nearly $250,000 just in unpaid wages and liquidated damages. You add attorney's fees onto that. If they're in a state that has additional protections, there may be other penalties. So these are not insignificant deals, and it can be quite a windfall for the employee. So what do we do about misclassified employees, right? It's one thing to say it's a problem. It's another to fix that problem, right? And there are strategies that we recommend. Number one, pay attention to who you have salaried and why, right? Don't just assume because somebody has always been salaried and they've never complained about it that means it's okay, right? Make sure you know what your salaried employees do. Make sure that they are doing things that fit the test that make them exempt, that allow them to be exempt. Check periodically on the job duties. Make sure that you have descriptions that are written that track what they actually do. And make sure, as I said, those job descriptions are correct, because it's not enough just to have on paper, hey, this employee is exempt, here's what they do. They need to actually do it. One fun twist, as I mentioned in the last example, an employee who was fired for not doing their job. We often have claims that come through where an employee was in a job that should have been exempt, but they later claim it wasn't. And their main reason is because, well, yeah, I understand what the job was supposed to be, but I didn't do any of those things. That's why I got fired. Meaning somebody who was a poor performer, who didn't actually do the exempt work, is actually somebody who may have been misclassified. So you have to stay on top of these things, which includes managing performance and ensuring that your managers, your other exempt employees are doing what their job requires. All right, mistake number 2. So now we're talking about my son. There are, by the way, a whole bunch of craft beers that have mistake in the title. So we're not going to run out of examples by the time we get to number 5. But mistake number 2 is keeping inaccurate time. So overtime, we talked about this first concept of exemptions, right? One question we have is who gets overtime and who doesn't. Another question we have is like, how much overtime do they work, right? And that means we have to track their hours worked. That's the phrase from the law, the federal law. It's the law everywhere, is this concept of work. But then there really isn't much of a definition of what actual work is. And so we spend a lot of time as attorneys advising and litigating and fighting over whether something is or isn't work. But there's three common things that happen where, again, well-meaning companies set up structures, have practices that unintentionally fall out of compliance. And so we're going to talk about three of those today. We're going to talk about this off the clock concept. So people working before or after their scheduled shift, or before or after they clock in, or after they clock out, I should say. We're going to talk about rounding. So time rounding, this is, the where you take a time punch and you move it up or down to make it a little easier for the tracking of their time. And then we're going to talk about just when we let employees themselves track time, and if we accidentally or maybe not accidentally, take and accept their time when it's inaccurate. So the first one, pre-shift work scenario. So we're going to have a handful of these scenarios. I'll kind of give you a second to read along with me and think through what you think about this. So Carrie arrives at work 20 minutes before her scheduled start time. She spends 5 minutes preparing a special soap mixture. Then she puts her tools in it. She's a mechanic. She wants to clean them off before she starts her day. While that soak is created, it takes 5 minutes. She lets the tool soak for 15 minutes. She goes to the break room. She, spends her time on the phone, drinking coffee, talks about Tim Robinson's new show. I haven't seen it yet, so no spoilers. I also haven't heard definitively whether it's funny or not. In the photo, in case you're wondering why I chose this particular one, it's a reference to another Tim Robinson. He's a comedian. It's sort of an inside joke. I've always found when talking to large groups I don't know well, it's really good to ingratiate yourself by making nuanced, subtle references that people don't get. That makes people really like you. So that's what I'm doing here. So she spends that 20 minutes in total before her shift doing 5 minutes of soaking, 5 minutes of soaking and 15 minutes of talking. Is this time work, right? Is this something we have to track and pay? So here's the rule, and it's a great one, the continuous workday rule. So this is a rule that was established and exists everywhere that we deal with wage and hour rules. And it basically means this: your workday as an hourly employee starts the first time you do something that is integral and indispensable to your principal activity, and it ends the last time you do something that is integral and indispensable to your primary work activity. So if I'm somebody who's a mechanic, the question is, what's the first thing I do that is part of and integral to me doing my work as a mechanic, having clean functioning tools? That probably fits. And then what's the last thing I do? In my day, I get paid for all the time between those two things. And what this does, if you think of the practical effect, is it stops employers from watching you all day, right, with a stopwatch and starting and stopping every time you work versus you don't work. There's an Office episode, by the way, as a labor and employment attorney, there's an Office episode for everything, right? But there's one where one character has a stopwatch and tracks every moment the other employee isn't working. If they yawn, if they step away from their desk, if they take a drink of water. This rule, the continuous workday rule, is what prevents employers from doing that in practice. Right? We can't start and stop and pay employees for every moment. If they look away from their computer, we don't get to take them off the clock. The exception, and we'll talk about this in more detail in a little bit, is bona fide meal periods. But otherwise, all that time from start to stop is paid, which means, if we go back to our friend Carrie, is that 20-minute period paid time? It is, right? So the 5 minutes for preparing her tools, that's an integral and indispensable task. That starts the clock on her day. The next 15 minutes, right, where she's sitting around doing nothing, it's not long enough to be outside of the continuous workday. It's not a bona fide meal period. It's a short break. And because of the continuous workday, that whole period is paid. And this is very important. And by the way, as workforces become sort of more comfortable with each other and less formal, these rules are where you see like a lot of leeway, right? Employees, hey, I want to come in early, before my shift. Don't worry, I'm just going to do this small thing, and then I'm going to be on my phone, or I want to hang out with my friend who works here as well. We eat breakfast together. It's important to make sure nobody is starting the clock on their day before you want them to. So if Carrie wants to clean her tools and it takes her 5 minutes, there needs to be an arrangement where she's clocked in and getting paid for that time, or figuring out some other way to ensure that it doesn't happen where she's now getting 20 minutes of unpaid time every single day. We have to sort of be thoughtful about policing the start and end of the day, because something that seems insignificant, by the way, something that Carrie is voluntarily doing, right? She's coming in early. Nobody told her to come in early. We know she's doing it because we see her do it every day, but no one told her to, right? It doesn't matter if it's not explicitly directed. If she's doing it, if we know or should know about it and it's work, we need to pay for it. Another example of inaccurate timekeeping comes from rounding. So rounding is math, so it's not going to be possible to avoid math when we're talking about rounding. But rounding is this idea that if somebody clocks in at 7:01, we round their time to 7 o'clock, or if somebody clocks in at 7:14, we round their time to 7:15. I would say the majority of the employers that I work with have some kind of rounding policy. 15 minutes is sort of the maximum or the longest period of time you should be rounding to. Some employers will do it to a 10-minute round. Some will do it to a 6-minute round. Typically, it's some fraction of an hour. And it just makes it easier, right, to track how much people are working, to pay it, to do the math on the comp side. And it's a steady sort of standard practice everywhere. We're going to talk about kind of how the rules work now. My warning to you all is that rounding is becoming less and less defensible, partly because rounding existed in a time when people were using hand punched clocks and doing payroll by hand, right? This idea of in 2025 you need to round to a quarter of an hour so you can figure out how much to pay somebody, ignores the fact that every one of us has in our pockets, on our wrists, on our computers, a million different ways to do that math to figure out how much it is. And so there are definitely states that are on the verge of or have already outlawed rounding. California is a great example, where they're going to say you got to pay and track time to the minute. You got to pay to the minute, right? We don't get to round anymore. They might say to the second eventually. There's actually a fun opinion in California, whereas they get stricter on timekeeping. They want to make it clear. There was a judge out there who said, don't let anything coming from our court, the California Supreme Court, suggest employers should be implanting tracking devices in their employees for the purposes of paying. So if at any point today you think, I know how to solve all these, I'm going to start putting trackers in my employees, at least one judge on the California Supreme Court does not think that's a good idea. We can talk about it. Again, I'll give you my email at the end. But rounding. So that's my warning is if you are an employer who rounds, or if you leave today thinking, oh, rounding sounds pretty cool, I want to try that. Just know that depending on your jurisdiction, it's already risky, and everywhere I think it's going to get riskier. But the general rule on rounding is you can do it as long as it doesn't result in employees getting paid for less time than they actually work. So if you have a rule that's neutral and you sometimes round up and it takes time away, or you sometimes round down and it gives time to the employee, if that ultimately ends up paying them more or paying them the same, it's fine. But there's a trap to this because everyone comes up with a neutral policy. All right, we're always going to round to the nearest 15 minutes. That's neutral. But then they have other rules in place that cause that neutral policy to not be neutral. Right, so they'll have overlapping rounding rules, and it causes employees to lose time rather than gain it. Or they'll have supervisors who review time records and will manually adjust time records that are otherwise paying employees too much, but leave alone the rounding that went to the company's benefit. Or attendance rules that tell employees when they can and can't clock in, and you put that with the rounding, and now most of the rounding is going in favor of the company. So here's an example of that. We got Acme Brewing. By the way, I picked Acme Brewing because I thought Acme was like a safe generic fake name, and then of course I looked it up, and there's at least an Acme beer being made out on the North Coast Brewing. So not an intentional reference. Nothing in this slide actually refers to anything North Coast Brewing is doing. But let's assume Acme is rounding to 15 minutes. Again, that's common to round to a 15-minute period. It is a facially neutral policy because everything's getting rounded to 15 minutes. It goes up, it goes down. Sometimes it's for the employer, sometimes it's for the employee. However, they also have an attendance policy, and that tells employees when they can clock in. It says you can clock in up to 7 minutes before your shift, and you can clock in if you clock in 3 minutes or later, you're going to get a tardy. So that has the result. What a slide, man. You can tell I love wage and hour law because this makes me excited. So this creates a practice, right, that is not neutral. So now we have the time. 7 o'clock is when they're scheduled. In theory, right, red is to the employee's benefit. The light blue is to the employer's benefit. In theory, those boxes are the same size on the top, right? So in theory, if you sort of threw times randomly at the wall, some of them would benefit the employee, some would benefit the employer. It would come out neutrally. You'd high five and say we're compliant. But in reality, because we have an attendance policy that punishes employees if they do things outside of certain windows, many more of the punches, in theory or actually, will land in that early time period, 6:53 to 6:59. Then we're going to round it to 7. We're going to take time off. Sometimes for this very narrow window of 2 minutes, employees will clock in late and we'll round back to 7 and they'll benefit 1 or 2 minutes. So if you have a policy or a set of policies that look like this, when you actually look at your record, you're going to see that you have employees who are typically losing time. And the nice thing is, because of policies are, these, or rather time records are typically electronic and available, like this is math you can do pretty quickly. Like, in a week, in a month, in a year, are my employees gaining time by rounding, losing time by rounding, or is it kind of roughing out, to equal? And so that's a quick way to check to make sure you're not going to find yourself being the kind of company that ends up on the bad side of a rounding claim. And rounding, going back to sort of the slide, so rounding is particularly problematic because if these are your rules on this slide, if somebody sues you, all they're going to do is challenge this policy. And that's an easy thing to do for a group of people, for a class or collective, because they're all subject to the same rules, and they're going to say, hey, these rules violate the law. Court, let me sue on behalf of everybody. And that's the kind of case that then takes a small thing, 1 minute, 2 minutes, 3 minutes every day, and it turns into a whole bunch of money. Another one, so this is just this concept of inaccurate time reporting. So I think some people have a perception you have to use time clocks. You don't, right? There's not a requirement to use time clocks. You do have to keep accurate time records somehow. I'm using 8 Beer here which I think is a Texas-based brewery. That's a quarterback who wore number 8 down there, had some success. But anyway, I digress. I'm not a fan. The risky thing that comes with doing something other than electronic timekeeping is if you let your employees report to you how much they work, they're not going to do it accurately. Most won't, right? And it's not, some will do it because they want to get paid more. Some will do it because they, are too lazy to record the exact minute that they start and stop. And so instead what you'll get are a whole bunch of time records that tend to be the same, right? So every single day they report 8 hours of work. Yep, I came here at 7 and I left here at 3 every single day. Courts hate that, right? When a court looks at that, they say, this person is not a robot, right? There's no way that they really started and stopped at the exact same time every day. And they will discredit those time records, and they'll allow an employee to say, yes, I was underreporting the time. They knew it. I should be able to sue for it. Now you're going to say, wait a minute, they were the ones telling us how much they work. How can they sue us for that? It's a good question. And the answer is because plaintiffs' attorneys have come up with a million theories as to why these people do this. There was pressure from supervisors not to report overtime, right? There was a culture of always reporting 8 hours no matter what, right? They're going to come up with some explanation for why they, for years, underreported their time, and they're going to sue for it later, and they're able to, right? There's nothing that bars them from it. All they have to do is claim and then prove that we knew or should have known that what they were reporting to us wasn't accurate. And that's should be a red flag if you have workers who are reporting the same hours every single day. There's a narrow exception to this if you have an employee who you can say credibly has and does work the exact same schedule every single day, but that's rare. It should certainly not be the majority of your workforce. So we're going to move on to mistake number 3. We see Bailey's mistake, which I think is a Maine thing. Maine with an E, not Maine as in primary. I tried to do a little bit of research just in case one of you out there was Bailey's mistake, but I think it's actually like an island of some kind. So if you were married to a Bailey, this is not referencing you. So what's mistake number 3? Botching the regular rate. I told you we get to do a little bit of math. We get to do a lot of math in this section. The regular rates, let's go back. Overtime, we figure out who has to do it. We figure out how much they work. If they work overtime, we got to pay them overtime. And that means we have to tell them, or we have to pay them 1.5 times the employee's regular rate of pay, right? Everybody knows 1.5, 1.5 times. The hard part is what's the regular rate of pay? It can be an employee's base hourly rate, but not always. And if you have hourly employees who you pay something other than an hourly rate, you give them bonuses, you give them commissions, you give them something else, there's a good chance that their regular rate of pay should also be adjusted, isn't going to be the $10, $12, $15 an hour that they get paid, because it has to include an hourly portion of whatever other things they get. So if I paid them a bonus, I have to break that down by hour, and I have to add that to their regular rate. Somebody who made $10 an hour, $15 an hour gets more when I'm calculating their overtime. Commissions are the same way. So if you have employees who get paid an hourly rate, but they also can earn commissions, those commissions go into figuring out how much their overtime is. And the same thing with shift differentials. That's the third shift, right? So somebody who works overnight, we incentivize it, we give them some extra money. if they get overtime while earning a shift differential, the shift differential has to also be increased to track the overtime concept. And the reason for this, going back to the 30s when these laws were first established, is employers were clever and they said, all right, I have to pay time and a half, the hourly rate. I'm going to put all of my employees at minimum wage. If they work overtime, I'm going to pay them 1.5 times minimum wage. And that minimizes the impact of the overtime. Oh, but my employees want to make more money than that, and competitively, I need to occasionally give them more. So I'm going to give them bonuses, not hourly bonuses, end of the year bonuses. And I'm not going to consider those as overtime. So when people work overtime, the number is lower. So the Department of Labor said, we don't like that. We're going to require you to think about all the compensation that hourly employees get. Most of it is going to go into the overtime, the regular rate bucket. And that way, when they do work overtime, it hits your pocket and it creates that incentive to not give somebody a lot of overtime. So here's an example. The text got small, so the slide's going to be good. The regular rate example. So an employee works, they get $20 an hour. They work 50 hours in a week. You guys can probably do the math on how much they're going to get, on the basics, right? So they get $20 per hour for their first 40. That's $800. Their overtime rate is going to be $300 because they get 20 times 1.5 times 10. And so that person is typically going to be making about $1,100. But that person also gets a safety bonus because we like safety and we want to incentivize it. So we give them money. Hey, every week you don't cut somebody's arm off, we give you $100. So this person didn't cut on somebody's arm off, they get the extra $100. You're feeling good about it. They're feeling good about it. Everybody can high five because they all have arms. And that's it. Except that $100, which is paying them for the performance, right, the work that they did, needs to go into their regular rate. And the way we do it, it's math, it's complicated somewhat, is we take the $100, we divide it by all the hours that they worked that week without cutting somebody's arm off, and they get a $2 per hour kicker on their regular rate, right? So now instead of making $12 or $20 an hour, now they're making $22 an hour. You can think of it that way. But that means they also need to get a little bit more in overtime. So we take that $2 per hour, we multiply it by 0.5. Now, some of you out there are immediately thinking, oh, that's wrong, it's a typo. It might be, there might be typos, or probably are, but this one isn't, because it's $2 times 0.5, because we already paid the 1.0 when we took the $100 and divided it by 50, right? Those 10 overtime hours were part of that math. If you're in California, some of you might be, the math is different there. Don't use this slide. I'm going to put the don't do this if you're in California proviso. Assume it applies everywhere, but it certainly applies here. But outside of California, because we took the 100, got to divide it by all the hours they worked, we've already covered the $2 part. So now we just need to add the 0.5. So we will owe them another $10. It's a perfect example, by the way, of somebody saying, all right, so it's $10. It's not nothing, but it's also not, $150,000. Like, should I really worry about this? There's a few things why you should. Number one, these claims are easy to prove because it's just math, right? They just get your payroll records, they get your time records, they do some analysis in Excel, and they say, oh, you underpaid because your regular rate was wrong. You owe us some money. And because the attorney's fees piece of that, even if it's not a lot of money, that can still be expensive and it's still worth doing for a plaintiff's attorney. On top of that, right, these cases get really complex. And so these cases can become very difficult and expensive to defend, because what happens if you have a bonus that covers 2 weeks or a month or a year, right? And so now when you pay a bonus in January that covers all the work that was done the previous year, that bonus in January has to be trued up for overtime that was worked the previous year, right? And that gets complicated. What happens if we're giving non-cash incentives, right? What happens if we hand out, a case of our product to somebody who, had a good week, but it was promised to them if they hit certain thresholds? Now we got to figure that out, right? Just like we have to tax it. All right, a lot of times we also have to put it into and figure out how to include it. And I should add, I say we have to tax it. I actually have no idea. I am not a tax lawyer. And I will say that as many times as I can. But there are other things that can complicate this math. So it's not as simple. Sometimes it's as simple as just taking an amount paid in a week and dividing it by the hours of the week. A lot of times it's not. And if you get it wrong, federally, you're going to be paying the unpaid overtime. In that case, it was $10. Liquidated damages turns it into 20. But state laws have all sorts of additional penalties that can be triggered even by small underpayments. Some are civil penalties, $100 per week that you underpay somebody. Some are wage statement violations. So, when you underpaid them, you gave them a wage statement, it was wrong, you have to pay for that. Some states have wage payment laws that have like interest and additional penalties if you pay somebody late, which means if you don't pay them at all, you've paid them late. Same for terminated employees, where you owe them everything at termination, and if you don't pay it, there's a penalty. Some of those get steep, and it can turn even small underpayments based on the regular rate into significant penalties and very expensive cases. I would say even outside of jurisdictions with all those other penalties, it's still worth getting right, because if they're wrong and you ever do have to defend against a lawsuit, this is a claim that ends up being sort of the slam dunk claim that allows them to justify pursuing all the other non-slam dunk claims, because they know they've got one they're going to win on. They know they're going to get some of their attorney's fees. They're willing to risk it and go after a lot more. Mistake number 4, I should have said it mistake number 3, that it was a reference to my 2-year-old, who is actually, of all 3 of them, probably the one who most legitimately is a mistake. I have not yet made mistake number 4, but here we're looking at Mistake Island, which looks like a nice, I think it says a West Coast double IPA. So there are 2 I's, 2 P's, and 2 A's in there. I'm a pretty kind of an expert on this stuff. So mistake number 4, stumbling into joint employment. This is not a clever pun where we now start talking about, like cannabis or hemp infused beverages. We're still talking about beer. Joint employment here is a reference to when 2 companies or 2 entities employ the same person. And where that happens, or where that can happen, is when we're dealing with somebody who's not our direct employee. A lot of times that's temporary workers, staffing agencies. It can be contractors, independent contractors. And the mistake that we run into a lot is assuming that there is some sort of impermeable, amazing firewall between the individuals who are treated as temps or staffing agency employees or independent contractors and us as an employer. That's dangerous. And then, assuming that firewall is there, we sometimes will then get caught up into having too much interaction and control over the work that they're actually doing, which immediately sort of erodes that firewall. Because 2 employers or 2 entities can employ the same person. And when they do, or whether they do, is a test that's going to vary. It's complicated. It's always totality of circumstances. And it will typically look at a few things. It will look at, or a couple of things. It'll look at the degree of control. So how much do I tell this employee or control what they do? The classic example of somebody who's not your employee typically is somebody you hire to paint your kitchen. If you say, I want a blue kitchen, and then you walk away and you come back and you have a blue kitchen and you didn't tell them what paint to use, how to paint, what strokes to use, what brushes, how to do any of it, right? If you just came back to a blue kitchen, you haven't done any of the kind of control that would turn that person into your employee. And the second test often goes to what we call the economic realities. Like, is this individual truly separate economically from you? The painter in my kitchen, absolutely, right? I'm a homeowner. They're a painting contractor. There's no economic tie there. Independent contractors, it gets messier, right? If I have somebody who only works for me as an independent contractor, who only gets paid because they do work for my company, right? Are they truly independent? Especially if I'm reimbursing expenses, if they have no ability themselves to lose money on the situation, it starts to feel a lot like employment. With temp agencies, a lot of times it's control that we're focused on, but it can also be the economic realities piece of, the work that they're doing and, on the line, if that work is truly the work that my company does, right? If it's the reason that my company is making money, it's hard to claim that they aren't our employee. And if they are our employee, there's a few things that can happen. Number one, you have to consider all the hours that they work when figuring out overtime. So if they're joint employment, you can't say, well, they work 20 hours for me and they work 20 hours for them. That means that or 30 hours for them, so they didn't work overtime for anybody, right? Somebody who worked 20 hours for one joint employer and 30 hours for the other joint employer really worked 50 hours and they get overtime. Same thing with calculating the regular rate of pay. We can't use a lower rate that we pay and ignore the higher rate that their joint employer pays and try to get away from paying what they're really entitled to in overtime. All of that gets sort of jumbled together. But the bigger point for you all is that if they are your joint employees, so you hire a staffing agency, they throw some people on the line to help you, get through a busy season or make up for absences, and you assume that there's that firewall and you're not responsible for what happens. They're not your employees. You didn't fill out a form. You didn't hire them, right? They're somebody else's employees. If you are determined to be their joint employer because you're out there directing the work, they're taking supervision from your employees, If that's the case, then all the employers are jointly and severally liable. That is, a legal term, right? That basically means each person is responsible, by themselves, right? So they can come after me as a joint employer, they can come after the other person as a joint employer, and we would each be liable for everything. I looked for a joint and several, a beer name, joint and several, and I couldn't find one. So I'm gonna put that on my list of potential craft beer names when somebody ever asks me if I have a list of craft beer names. So what does joint and several liability mean here? It means that if anybody has failed to comply, even if they're not your direct employees, you're responsible. So how do you manage that risk? For most of you all, and most employers, not dealing with contractors and not dealing with temp agencies is impossible, right? There are needs, there are reasons, good business reasons for using independent contractors, good reasons for using temp agencies. So I'm not going to tell you don't, right, or treat everyone as your employee, right? That's taking on costs and complexity and administrative challenges that you probably don't need. But what I will say is make sure that you are not assuming that everything is fine if they're not your employee, and ensure that someone is following all the laws, right? So just like there's joint and several liability if you screw up, there's also sort of joint and several, non-liability if somebody does a good job. So if you pay them correctly or the temp agency pays them correctly, as long as somebody pays them correctly, we're golden. So make sure someone's doing it, right? Use your contracts, use master services agreements, whatever you have with these temp agencies, use it with them to ensure that they know what they have to do, you know what you have to do, and that you're doing it. And if you can, right, negotiate an indemnification. Hey, you're responsible for payroll, you're responsible for calculating overtime. If you get it wrong and we get sued, you're going to cover us, you're going to pay our fees, you're going to do all of that, right? Look at your contracts and know what's in there now. It's possible, I bet at least somebody who's watching this video is currently party to a contract where you have agreed to indemnify somebody else for a claim like that, right? Where you have said, all right, if we get sued or you get sued, I'm going to cover all the costs. Know what's in your agreements before the situations arise, and negotiate differently if you can. And then finally, I mentioned I wasn't going to tell you to not use any temps or any independent contractors, but if you have somebody who you call a temp, again, like The Office, I think they had someone called a temp for several years on that show. If you have someone who's called a temp and they work for you every day and they don't work for anybody else, it might be time to go ahead and get rid of the temp label and hire them directly, right? And make sure that you take responsibility and ownership for the compliance so that somebody else doesn't screw something up and put you on the hook. And finally, mistake number 5. Again, this is not a mistake I've made yet, and that is choking on meal and rest breaks. So we talked a little bit earlier about the concept of meal breaks. It's that exception to the continuous work day, right? You don't have to pay for a meal break. And so we're going to talk a little bit about kind of this. This is a topic that could be its own presentation because of the enormous complexity that flows in from how different states handle it. So we're going to talk about kind of the most common rules, the most common issues that arise, but just know that, and again, Californians definitely know that this is not going to be a presentation where you can listen to the next 5 or 6 minutes and think, all right, I got meal and rest breaks down on lock, as the kids say. So the basics. Majority of states don't require it. I'm sitting in Missouri right now. If my employer wanted to tell me that I had to sit and work for 8 hours without ever leaving my desk, they could. There's some disability issues that could come up. But for the most part, there's no requirement for a meal break or a rest break in Missouri for employers or for employees who are over 18. That's true in the majority of states, which means most of you who are giving meal breaks and rest breaks to your employees, you're doing so out of the goodness of your heart / in order to have those employees continue to work for you. Meal breaks can be unpaid. Most meal breaks are unpaid for hourly employees, right? And they can be as long as they are bona fide. We're going to talk about that in more detail. Rest breaks typically have to be paid. That's because they're too short to be meal breaks. So they have to be paid as part of that continuous workday. And then for those of you, and some of you may have this, if you have a union in place, if you have employee policies, some of those can create an obligation to provide meal and rest breaks that goes beyond what your state requires. So track kind of all of these things. These are the basics. Let's take a look at a scenario. So we've got an employee named Damia. She wears a radio during her shift. It's pretty common in a workplace, especially one that has like a large, if you're working in a large location, you got to stay in touch, you use a radio. She always has it on during her 30-minute unpaid lunch in case somebody needs to get a hold of her. And sometimes they do, right? A supervisor or coworker will call on the radio and they'll say, hey, can you find my shoe? And she says, yes, I saw it over by the back door and they say, great. Sometimes she has to enter lunch early, right? She eats for 10 minutes. Somebody calls, there's an emergency, she goes back to work. Can those meal periods be unpaid? That's kind of the question. So the question that we need to answer is, are those bona fide meal breaks? Because if they are, then they're an exception from the continuous workday, and we don't have to pay for them. If they're not bona fide meal breaks, then they're not an exception, and we do have to pay for them. So to be bona fide, typically you're looking for 30 minutes, right? I think most of you have it in your head, a meal break needs to be at least 30 minutes. That's because that is the law. The FLSA says anything under 20 minutes is definitely not a bona fide meal break. Between 20 and 30 minutes, I guess, is arguable. Maybe there are specific circumstances why it might be enough, but for the most part, to be safe, recommend at least 30. I would even recommend maybe a little more than 30. That way, in case somebody doesn't quite get their full 30, you still got a shot. So what else makes it bona fide? There's two standards across the country, depending on where you are. You might have a court that has determined one or the other. So there's one standard that is completely relieved of duty. So that would mean somebody has absolutely no work obligations on them during the 30 minutes. They're free to do whatever they want. They could, run 15 minutes in one direction and run 15 minutes back from the other. Nobody can stop them. The other standard is predominantly for the benefit of the employee. So predominantly means not entirely, right? Which means that some pieces or some parts of that 30 minutes can be for the benefit of the employer. So that second test is obviously the more permissive test. Where I am in Missouri, we're in the Eighth Circuit, which is a federal federal court that covers certain states, and the Eighth Circuit has adopted that test predominantly for the benefit of the employee. Other states, California, completely relieved of duty. So going back to Damya, can her meals be unpaid? Probably, some, maybe. It's a classic lawyer answer, right? We like to say, yeah, probably, yes, but. So some of them. So this is how it works, right? When she has to go back after 10 minutes, that's not a meal break. That's not long enough. It's not even 20 minutes. It's not even close. Like those 10 minutes were not a meal break. So not only does she need to be paid for the time after she gets interrupted, but she needs to be paid for the 10 minutes that was the start of your meal break, right? She needs to get that whole period of time back. This is an important one because a lot of times employers will have a policy of if you get interrupted during a meal break, you clock back in, you go back to work. Great, that's what you should do. But the problem is that when you clock back in, you still have 10 minutes where you were off the clock, and those 10 minutes need to be paid. There's no reason or no legal reason not to pay for those 10 minutes. So make sure that you are adjusting or somehow making sure that 10 minutes gets paid. The next question, right? What about on the days where she just gets a radio call, it takes a minute or two? Is that going to affect it? If she's in a state where the test is completely relieved of duties, then that becomes a paid meal break, right? Even the obligation or the interruption where she responds to the supervisor is enough. She was not completely relieved of duties, that's paid. And the other states, Missouri and others, if 29 minutes is hers and 1 minute is spent on the radio, that is certainly predominantly for the benefit of the employee, and it would not have to be paid. The additional, trick that can come up with meal breaks, we, in a scenario that we had for Damya, she was clocking in or out. A lot of employers use an auto deduct for meal breaks. So these are employers who have employees not clock out, not track their meal breaks. They don't tell you when they start and stop. They just know they're supposed to get 30 minutes. And we take 30 minutes off of their pay every day. We schedule them from 9 to 5:30. We pay them for 8 hours because we assume that during the 8.5 hours they're on the clock, they're taking 30 minutes of an unpaid meal break. We call that an auto deduct policy. Auto deduct policies are common. They are commonly challenged, right? We have lawsuits every day. Yeah, probably one somewhere in the country every day, that we're defending or that we hear about, where an employee is claiming that auto deduct policy was unlawful, it underpaid everybody. And the challenge of the auto deduct policy is that you don't have a record of the meal break, which means you're going to have time records that show an employee clocked in for 8.5 hours, and you're only going to pay them for 8 hours, right? So that puts the burden on you as an employer, basically to argue against your time records. And to do that, and to prove that employees didn't get shortchanged somehow, the solution is to document carefully. Right, so make sure there's a good, clean policy that employees are aware of, that they're trained on, that they know what to do if they don't get a meal break, so they can get paid, so they can stop the auto deduct. So they know what to do if their meal gets cut short by a little bit or by a lot, and then make sure that we act on that. So if an employee comes to us and say, "Hey, you're going to take 30 minutes off for the auto deduct, but I only got 15 minutes or I only got 20, that we're tracking and that we're paying for that. Or alternatively, you can stop auto deducting. It is kind of waving a flag and asking for trouble in some ways, and their documentation is the way to fight that off. We recommend that if you do auto deduct, that you have a form that is readily available, that is used, right, that actually gets tracked, kept, and make sure that it's something that employees know how to do it and they actually do it. Here's an example of what that form can look like. Next up, we've got choking on meal and rest breaks. The last piece is don't forget state or local laws. So we talked about it before. What we talked about so far is more or less down the middle, but a lot of these other things are far more complex. States will require specific meal breaks. If somebody works more than 10 hours, they typically get 2. If they work longer than that, sometimes they can get 3. Right? Paid rest breaks are required in many states. They'll have specific rules, 1 every 4 hours. 1 every 4 hours or a major fraction thereof is the phrase in California. Sometimes they'll have standards, heightened standards on what constitutes a break. So in California, for example, Damia had that radio. In California, just having the radio, even if it never makes a noise, even if no one ever interrupts her, but just the fact that she has the radio on her and it's on, and she's in theory listening for it to ring or to buzz, is enough for that not to be an unpaid meal break. We'd have to pay her if the expectation, or if she chooses to listen to the radio. So in California, tell them to turn the radios off. And then there's additional penalties that make these very expensive. So the last couple of slides are going to be quick. We'll get you out of here on time. The first one, are internal risk indicators. So these are the sort of things that as you're talking about wage and hour, if the way you make yourselves feel better, right? If the warm hug you give yourselves is to say, all right, AJ just told us that this is unlawful, but we've always done it this way and we've never had a complaint. Everyone that we know in the brewing industry does it this way and it's fine. That is a red flag on letting yourself get diluted by this idea that it's intent that's based it, right? Or that an employee complaint is going to motivate what happens next, right? It's not going to be an employee who thinks they're underpaid who files the lawsuit. It's going to be somebody who feels treated unfairly in some other way, typically goes to a lawyer, and that lawyer doesn't care about discrimination. They care about how you got paid. And the other one is your payroll vendor. So I mentioned looking at agreements for temp contractors, those sorts of things. Look at your payroll vendor agreements as well. They will almost certainly have shifted the obligation to comply with all of these laws on you, right? Which means if they're doing it wrong, it's not their fault. You're the one who's supposed to be making sure they're complying. And it's not a defense, and it won't protect you to say, well, we use a sophisticated payroll vendor, and as a result, we think we're fine. If these are and then obviously the last one that's never had a complaint. Again, it's not typically, these are complex laws. Employees typically don't know that you're doing something slightly out of compliance until they talk to the wrong person. And then, what do you do next, right? What are the things what does it look like to comply, to sort of have a culture that defends these things? Auditing, meaning looking at your records, figuring out where you have problems, very important. We help with that. It can start just on your end of like taking the topics and things that you hear, in this presentation and others, and looking at how you actually operate and flagging, where are possible concerns. Training your employees, both the hourly employees and the managers, on how these laws actually work, right? And part of that training is making sure managers not only know how it works, but also ensuring that they understand the why of it, right? What are the consequences of doing these things? Because it's really easy for a manager who's just trying to accomplish a goal to think, that's not such a big deal this time, right? Or this moment, it hasn't hurt us in the past, I'm going to do it again. And so helping them understand why what the risk is, what these cases look like or can look like, will hopefully help them in that moment realize that they need to not only accomplish their goals, but do it in a way that complies with the law. And then this last piece is just ensuring that your employees and your policies and all of these things are being done consistently. All right, make sure that there's a review, not just a one-time audit, but a daily or weekly or monthly check to make sure that we're doing things consistent with our policies. And that will help ensure, or at least reduce the risk of what comes next. So I appreciate you all taking the time to hear from me today about wage and hour compliance, 5 common mistakes that employers can make. If you have any questions, please do reach out to me. My email is on the screen, ajweisler@hushblackwell.com. I enjoy hearing from people about wage and hour issues. My phone number is Googleable as well. If you want to give me a call, we can talk about other things that interest me, like math and my children, none of whom are mistakes, in case they happen to watch this and get to this last slide. But otherwise, really appreciate the time and hope you all have a wonderful day.
Thanks for watching. If you enjoyed this session, we'd love to see you in real life. We host in-person workshops across the country for craft beer professionals just like you that are held in some of the most exciting beer destinations around. These immersive events are designed to help you grow and connect with others. You'll meet peers from across the country and leave with actionable strategies for success. Connection has never been more important, and you can learn more at cbpconnects.com. Cheers. See you there.